Good morning, everyone, and I just want to thank you so much for joining me today. In this talk, I'll be talking about my new book on privacy and technology. And what I tried to do in this book was, I realized it's actually, I can't believe how time has flown. It's been about 25 years since I started thinking about privacy, writing about privacy. I actually thought even before it started on privacy even before the turn of the century. So I realized it's about a quarter century, and it was thought worth taking stock of where privacy has been and where privacy is and where privacy is going. Also thought that it would be good to revisit what I had thought about privacy in the beginning and whether that holds true today. Things have changed, but in some ways things have stayed the same. I also think that we are now in a rather precarious time. I guess I could say that almost any time, but I think now it's particularly precarious because we're seeing a deregulatory push emerging from the United States and the Trump administration. It seems to be now catching on everywhere. Everyone's getting sick. It's a kind of pandemic of deregulation, it seems. Even in the EU, I hear talk of simplifying the GDPR, rolling back protections or weakening protections, which really troubles me because I think that we should be going in exactly the opposite direction. So what I'd like to do today is go over some points in my book and discuss with you how the law is trying to grapple with privacy, both in the United States and the EU, and then what the law might be getting wrong about this, and what the law should do differently. Because ultimately, while I'm definitely against deregulation, that doesn't mean that I think that existing law is up to the task. And although I think the GDPR is the best law out there on privacy, there still are a lot of things that need to be done. The GDPR is not going to be enough to address this problem. So I'd like to begin, actually. I thought that in today's world of AI, I thought I'd ask AI, what does it think the future of privacy and AI is going to look like? What's the future world going to be? And this is the picture it paints. It looks great, but if you look closely enough, you'll see there's no humans in it. So that's not very good. I tried again. So this is perhaps our future. Maybe this is starting to look more realistic in terms of what we are going to be facing in the future if we don't intervene significantly to stop something like a society like this. I'd like to start with just some thoughts about privacy, and we often hear people say that privacy is dead, and I constantly hear this, but I went back and I just looked through some headlines from years ago. So go back a few years, and here's an article, Privacy is Dead, from 2022, 2021, The Death of Privacy. Here we go, Privacy is Dead, 2020, that's 5 years ago. But let's keep going back. The End of Privacy in 2019, Privacy is Dead, many headlines, here we go, 2017, 2015, here we go, 2014, 2013, 12, 2000. I'm going to skip a little bit. The End of Privacy, I remember these things coming out in the turn of the century. When I started on privacy, I thought, okay, this is interesting. I'm about to start doing privacy for my career, and they're already saying it's dying or dead. Well, even at the turn of the century, it was dying right before 97, 93, 1970. And we'll go to 6. I'm going to stop here, but you get the point. Privacy has been dying all the time. But when exactly did it die? Because we keep hearing it's dead and it's dead and it's dead. When did it die? Well, I created this cartoon that kind of captures why we keep hearing all this stuff about privacy being dead, about how technology, as it evolves, keeps threatening privacy. And so go to the 1870s, and we have the telephone, and soon after the telephone, we had wiretapping. And so I have someone saying privacy is dead. Here we go when portable cameras came out, privacy's dead. Go to the 1960s, mainframe computers, again. 1980s with personal computers, 1990s with portable phones. They kind of look these clunky things like that. Then we get portable computers in the 2000s, smartphones in the 2010s, AI now in our decade, and then I projected it into the future. Holographic life projection, which probably everyone will have now instead of social media. I think that's quaint. Right, just social media. Well, now you can project your life 24/7. Everything you do and experience projected. And again, privacy is dead. So we're going to hear this constantly. Privacy just keeps dying. Will it ever stop dying? This is like a death scene from like one of those horror movies or something where the thing won't die. I think that privacy's death is we just keep hearing it, but it's still not quite dead. And that's why I think it's very important that we do something. Because it's generally one of the myths that we encounter with privacy. It's dead, so we should give up, right? That this is all, and I'm going to talk about, and in the book I talk about many myths, that just we should give up. We shouldn't regulate. And we hear this a lot. And I think that's exactly the wrong conclusion to make. I think privacy is kind of under threat. It is kind of dying in certain ways, but it's not dead. We have to save it. It's like an ER patient, and it's always going to be an ER patient in the emergency room, and we're going to have to rush to do things to help save it, and it's always going to be this way. But we need to do something, and we shouldn't let privacy is dead be the give up, throw up our hands and say, it's too late, we can't do anything. We're not going to try. So there are many myths that get in the way of effective regulation. And in my book, I spend some time talking about these myths because I think they really do a lot of damage. They do conceptual damage, but also practical damage because they make it so hard to regulate here. Because all these myths are things that basically are trying to stop or inhibit regulation or weaken regulation. And I'll talk about some of them. And the one that I spent a lot of time talking about is the myth of the privacy paradox. I even wrote a whole paper on this, and I talk about this briefly in the book. This is the myth that people really don't care about privacy because though they say they care about privacy, what they do demonstrates they don't seem to protect privacy that much. And so you can ask people in a poll, hey, do you care about privacy? Rate it 1 to 10. And they'll be like, it's not just a 10, it goes to 11. I love privacy. I think privacy is the most valuable thing in the world. Will you please give me your social security number and other personal information in exchange for a 10-cent discount? Sure. What do you want to know? And we'll see this constantly, where people will say they really value privacy, but then you look at their behaviors, and they're using all sorts of invasive technologies, invasive apps. They're giving up their personal data, doing all these behaviors that are really not privacy protective at all. They're terrible behaviors for privacy. And so commentators would say, look, at the end of the day, talk is cheap, but actions speak louder than words. And what people do really matters, and they really don't care because that's their behavior. And so we shouldn't protect privacy because, yeah, people talk and they say they do, but they don't really value privacy. Let's focus on behavior. And I think this is wrong. I think the privacy paradox is a myth. It's a myth because we're really talking about two different things when we talk about the privacy paradox. The attitudes that are polled are people's actual views on how they value privacy. The behavior is not the same thing. The behavior reflects a particular risk calculation in a particular context, in a particular situation. So when I choose to use a technology like my phone, I'm doing it in a context. I'm not making a general statement about my privacy. I'm making a statement about what I think the risks are and what I think the benefits are for using this phone. When I use any technology or any app, I'm making an assessment about the risks and the rewards, and I'm going to make that balance. And the problem is that consumers really can't assess the risk very well, and a lot of times the choices they have are not really that practical. How can you live? Maybe there are a few people who live without a phone like this, but it's really hard to live in society today without this phone. I mean, I'd say, hey, where do I go for this conference? How do I do the conference? If you don't have a phone because the schedule's in the phone, it's electronic, you can't do it. And so many things depend on technologies that we really don't have much of a choice. So I created this cartoon to kind of capture this situation. So I have this guy, and he's walking through the desert. He's dying of thirst, barely hanging on. But luckily for him, he encounters another person who says, I'll give you some water if you just give me some information about yourself. And so the guy says, sure, what do you want to know? I'll tell you anything. So the person concludes, people really don't care much about privacy these days. And these are the choices that we're given in these contexts when we're trying to make these decisions. So I don't think that we can make this conclusion from people's behavior. I don't think we can make many conclusions from people's behavior. The fact that people say they value privacy is very important, and the behavior indicates that things are rigged and set up so that we really can't have what we want. And we really don't know what we're getting into when we're making decisions about data, or the benefits are so clear and hard to give up that we ultimately make sacrifices that we would prefer not to make, but we have to. Another myth is the myth of technology exceptionalism. And this is the myth that technology is so special, it's so complicated, that regulators really should avoid touching it. It needs to be treated specially, with special gloves, and courts and policymakers are just not smart enough, just not capable enough to regulate it. So hands off, technology should be treated differently than any other thing. And I think this is a very pernicious myth, because it's basically saying you go and do what you want and you can be unaccountable. You don't have to answer to anybody because you're just somehow smarter and more capable than everybody else. Technology is somehow so much different than anything else. But I don't think it is, really, at the end of the day. I think that technology exceptionalism shields technology from scrutiny and responsibility. What they're essentially saying is, trust us. We don't want you to really regulate us. We don't want to be accountable. And I think that's a big problem. But we hear this a lot. I hear these arguments constantly. Then there's another myth that regulation stifles innovation. And you probably heard this a lot, right? Well, we need to innovate. And if we have regulation, then it's going to stifle our ability to create new technologies. That's why, all the big tech companies are primarily from the US and China. It's because of the GDPR, the evil GDPR that single-handedly has stopped all technological innovation in the EU. And this, basically, to use a technical legal term, is bullshit. Regulation really, I think, has nothing to do with it, in fact. Regulation steers technology. It tells the technologists, these are the values we want you to do. These are the problems we want you to solve. These are the goals we want you to achieve. It doesn't stop them from innovating. It tells them how to innovate. A seatbelt is just as innovative as a faster car, as a gas pedal. There are a lot of things in technology that are very innovative, and technology companies can do it if the law requires it. And they're often good things that technology can be steered to do. One thing I've always found interesting is that when you ask a tech company, hey, can you create a solution to this problem? What can your AI do? Can your AI solve any problem? I've got a problem. Can your AI solve it, or can't it solve it? Oh no, it can solve it. Anything, whatever. Sight unseen, whatever problem you have, whatever you want to do, our AI will do it, right? They'll sell it like our AI solves, it'll cure cancer, it'll save the world, whatever. You know, it's going to be perfect and beautiful and make the world do whatever you want to do. Then you ask a company, hey, will you, can you just do this can you comply with regulation? Oh no, it's too hard, we can't do it. So I created this cartoon based on Star Wars. Tech companies here, Darth Vader saying, I'm all powerful, I can do anything. And then on the other side, Yoda saying, follow regulatory controls and privacy protections, you will. And then Luke says, I can't, you ask too much, it's impossible. This is what we get from the tech companies, but it's not impossible. In fact, tech companies are very good at following incentives. That's what companies are. Companies are creatures designed to follow incentives. That's what they do. And if you tell them, make safer, more privacy protective AI or more privacy protective technologies generally, guess what? They're going to do it. They'll do it if you incentivize them to do it. Otherwise, all they're going to do is try to just get profit. So I think that regulation, essentially, it actually protects companies. It protects companies that innovate thoughtfully and responsibly by preventing companies that don't from having an unfair advantage if they don't. And that's what good regulation can do. It sets good incentives. It gets companies to care about privacy, and instead of just innovating just for profit or whatever weird visions of society that they might ultimately have, no. You can't have the James Bond villain version of the good society or whatever you're looking to do. You have to care about the values that we have as a society and protect them. And I think if we force them to do it with regulation, they can do it. Another myth is the myth of technology neutrality. This is the myth that technology is neutral. It's better than humans because technology isn't biased. Technology doesn't have prejudice. Technology just doesn't care. So it's neutral and pure, and it's going to decide things better than humans can. In fact, I actually think this is a total myth. Technology is not neutral at all, and it's not neutral because it's created by people for particular aims. It uses, and it's trained on, AI is trained on human data, which is already infected with bias. And as one professor wrote, wrote a paper called, bias in, bias out, for garbage in, garbage out. You put bias data in the thing, you're going to get outputs that are also biased. So I think we have to recognize that technology is always created with power and for power. And it is really a tool wielded by humans for human aims. And so there's never going to be neutrality in that kind of situation. Now, to show this, I created another cartoon. This is a cartoon about data. This first person says, what's wrong with a robot? He's a total asshole. He constantly hurls insults, has crazy extreme views, makes threats, and most of what he says is false. I don't understand why our AI is so bad. Person 2 says, well, we did train him on data from social media. This is what we're getting. We are getting bias, but now it is being reified baked into the technology, and then slapped on with this facade that pretends that it's somehow not biased. I think that's even worse than before, when we actually would not be fooled by a myth that something was biased. So today, what can the law do? And in fact, we're living in a really interesting time because this is a golden age for privacy law. We really have seen tremendous developments in the law. The law usually moves at the speed of a turtle, And here it's moving incredibly fast. It's actually amazing how much law has been developed in this quarter century. We've seen so much has happened. Of course, dozens of laws all around the world. I'll start here. The GDPR 2016 becomes active in 2018. This is the strictest privacy law in the world, the most influential privacy law in the world, I say data protection law. It is it's a real achievement. And we've seen a lot of laws that are being passed all around the world. 160 countries or more have passed a comprehensive privacy law. The United States has a lot of sectoral privacy laws, very narrow laws dealing with specific things and specific industries, but it lacks a comprehensive privacy law. A lot of attempts have been made to pass a comprehensive federal privacy law, but Congress it can't really do that. Congress is essentially, I think, in the United States, really for this whole century, has been a pretty inept body that can really only do bad stuff, mostly. If you look at the latest bill, it's like a whole garbage dump of like horrible things upon horrible things. I've just been reading the headlines about it, and just like every time reading, like, oh, here's another horrible thing and another horrible thing. It's terrible what's going on in my country. Kind of rather just, I think we should just dissolve Congress at this point. It's kind of worse than it should be doing something. Instead of doing something, it's making things even worse. I don't think Congress is up to the task of passing a comprehensive privacy law. I don't think that if it were to try to pass a comprehensive privacy law, the law would be any good. It would be awful, and it would be bad. There were attempts earlier. They would have vested the enforcement authority in the FTC. It's not clear the FTC is really going to be functioning much longer. It's probably, who knows what's going to happen, but it's basically an arm of the Trump administration that's going to just do whatever he wants and just be used like the FCC is being used as a tool to go after people Trump doesn't like. So we really wouldn't have effective enforcement if we had that law. But we have the states, and states have passed privacy laws starting 2018 with California, and we have about 19 states now that have passed these broader privacy laws. They're not as broad as the GDPR because they do exempt smaller businesses, and a lot of them don't cover nonprofits, and they don't cover the government, so they're narrower, and they only cover certain things. But for the US, it's pretty broad. For you, it's not. So ultimately, they're saying, oh, the US law is the Wild West, but it's not the Wild West. There actually are lots of different laws. And in addition to the the broader state privacy laws, there are subject-specific state privacy laws, health privacy laws, biometric privacy laws. There are children's privacy laws and others. So we really see a lot of law in the United States. And some of it's actually pretty good, and a lot of it's actually pretty bad. But there's a fair bit of law out there. And more and more every year. It's hard to keep up with all that's going on. So in a way, this is a good story, right? We're seeing this immense legislative response to privacy, but I have some bad news. And the bad news is that, unfortunately, I think a lot of the law is not good enough. Some of it's downright awful, and a lot of it is coming up short in ways that I think are very problematic. Not just a little bit short, but a lot short. And I'll even say that about the GDPR. It comes up a lot short of what needs to be done. And I'm going to tell you why I think that in the rest of this talk. So one of the things especially we see, especially in the United States, is that a lot of the laws are based on a self-regulatory approach. And in the early days of the internet, this was talked about. The internet should be this free zone. Companies can regulate themselves. We hear this all the time. We've heard this throughout history. Companies can regulate themselves. Never has worked, ever. I don't know why we keep falling for this, or policymakers keep falling for this, the idea that companies will somehow be good on their own just because they have some inherent innate goodness. It's just not the case. But a lot of the law is essentially self-regulatory with a slight set of additional requirements in the United States. So essentially companies just declare what they want to do in their privacy notice, and then the law says, adhere to your promises. And it's interesting because companies can't even do that well. They still don't do that, but that seems a pretty easy thing. It doesn't limit them in any particular way, in any meaningful way. So I created this cartoon to capture the system and how the US approach, which is called notice and choice, works. Foxes were regulated like privacy. So I created the Fox law says, declare how many hens you want to eat, then only eat that amount. And then I had my illustrator, I have a great illustrator who helps me illustrate these cartoons. Draw these foxes like tech bros, so you can probably guess who they might be. The first fox says, this law is outrageous and burdensome. And the fox 2 says, yeah, it's stifling my ability to innovate. These laws ask so little of companies. These laws are very easy despite the fact that they whine and complain, oh, it's so hard and burdensome. Companies are very good at producing paper, documenting things, creating programs. They'll say, oh, we threw millions of dollars into our privacy compliance. But that's just, you ask how much revenue they've made. We've made billions of dollars in revenue, and we have like a teeny little privacy budget. That's barely anything. They barely spend anything or do anything. They complain about the most minor restrictions on things. The law actually really doesn't ask much of companies. I think like the EU AI Act, for example, doesn't really ask, at the end of the day, it really doesn't ask a lot. It's a very minimal regulation. What's going wrong with the law beyond this? Well, a lot of the law rests way too much on individual control. And this is a model that the law everywhere, I think, relies a lot on, including the GDPR. It relies very heavily on the idea that we need to empower the individual. We need to give the individual rights so that they can control their data. And so we have all these rights that the law gives people. And the GDPR has a big chunk of the GDPR, not the whole thing, but a very big pillar. One of the main pillars is privacy rights. And the same thing with a lot of the laws in the United States. Privacy rights, that's what is going to protect privacy. And I think privacy rights are good, so I'm not advocating that laws should omit them, but I think that laws put way too much weight on them, way too much weight. And this is why the laws fail. They put too much they're resting too much on this edifice. So what's wrong with privacy rights? And I'd like to talk a little bit about some of the problems, why the rights don't work. The rights really create an endless burden of chores. People don't want to do this. It creates a mirage of control. But really, people don't want to do this. I'm sorry, but yes, I like the fact that I have a right to correct my records. I like the fact that I have a right to delete, but I don't want to spend the time being a proofreader for thousands of companies. No, thank you, a free proofreader. I'm supposed to access records at thousands of companies, find out what data they have about me, find out if they need the data still for the purposes for which they collected it. Well, how am I to know whether they've achieved the purposes for which they've collected it? Now I feel like the kid in the back seat of the car. Are you there yet? I have to ask the companies, I want you to delete it. Why should I have to do this? Why should I have to keep track of all this? I'm sorry. And they're kind of burdensome, and they're an annoyance. Every time I come to the EU, web surfing, maybe you're used to it, but I want to scream at the cookie banners. Do you want cookies? Click yes, click accept, cookies. The last thing I want to do is get the cookie banner. I usually just click accept which basically is not that I accept it. It's basically this is what it translates to. Go the fuck away. Because I hate it. I don't want to deal with it. I don't want to think about it. I want to get to my site. The time that I want to think about cookies is never. I don't want to deal with it. Most consumers don't. But the law kind of forces it upon them as if they're supposed to figure out like all the stuff. Do you like this kind of cookie or that kind of cookie or whatever cookie? And, just do these settings and click these toggles. People don't want to deal with that in most situations. The law gives people this privacy self-management. Oh, you can manage your own privacy. We're going to give you all the controls to manage it. But I don't think it's possible for people to manage their privacy very well in today's world. Hardly anyone reads privacy notices. They go on and on and on. These are things written by lawyers to basically say nothing. If you read them, they're impossible to understand. Even if you could understand, they're basically trying to say, don't pin us down. We kind of want to use our data however we want to use it. We're going to share it with a whole bunch of parties, and we're going to do whatever. But, please trust us, blah, blah, blah. We love your privacy, and it's awful. I created this cartoon because a lot of for this companies really don't fully know how they're going to use their data. So they said, we don't know what data we have about you. We don't know what data about you we have or what we're doing with it. When we figure this all out, we'll let you know. It's constantly changing, right? Suddenly now we're seeing companies decide, oh, we want our AI too. So we're going to change our privacy notice to say now we can use your data for AI. And they're constantly changing these notices all the time to try to match how they want to use the data. Even if people read the notices, which they don't, studies show that fewer than 1% actually read privacy notices, people are not going to understand them. And there's a dilemma with privacy notices. The dilemma I call the dilemma of complexity and simplicity. The problem is that privacy is very complicated. If you really want to adequately explain privacy, then you have to have a very long and detailed privacy notice. What do I need to know? I feel like, okay, I studied privacy. What do I want to know about a company? Well, I don't want to know, this vague, platitudes. I want to talk to the privacy officer. I need to talk for about many, many days. Tell me about your privacy program. Do you have training? How do you use it? I'd like to see your vendor agreements and how you share it, what's in the agreements. I'd like to see, your data retention schedule. I'd like to see, all sorts of details about your policy. I'd like to see the data that your algorithms are trained on. I'd like to see your algorithms. I'd like to talk to your, to see the values of the technologists that are working, your engineers. I could just go on and on. Security. You have reasonable security? What does that mean? I want to know, do you do pen testing? Do you have, how good is your encryption? And I could go on and on. But there's the detail that I would need to know, the kind of complexity to really figure out, should I allow them to use my data? Because ultimately, the decision people are making, right? The decision we're making with technologies is a simple decision, right? What are the benefits? What are the risks? Are the risks better than the benefits? Is it better for me to use the benefits versus the risks? There's a cool app. Oh, cool, I can see how I look as a cat. The benefits are, I can look at myself as a cat. The risks are, what are you going to do with this data, in fact? And so, that's the calculation. How do I know what the risks are? Well, these notices, but they're not going to explain it in that great detail. Actually, the thing just happened the other night. My son, this is this cool app. You can take your face and you can move stuff around in your face and make your face look weird. I thought, that doesn't sound very good. This company's going to get your image of your face, and what are they going to do with it? And I didn't have time to go and read through I have to read through the privacy notice and figure out all the risks, and are they going to share the data? What are they going to do with it? And so, no, I want to use the app. And within a second, he has the app installed on his phone and he's using it. That's the problem. So what if we made privacy notices simple for people? Oh, okay, let's make them so people can understand it. Well, the problem is that they're too simple. Now they're not saying anything meaningful anymore. And that's the dilemma, right? Privacy is too complicated to describe in terms that people can actually understand, because you'd have to have like a book for every private or every company. And this is the problem. It puts too much onus on the individual, too much on an individual to figure all this out. I shouldn't have to figure all this out. I should be able to use this and technology without worrying that it's going to kill me. Another problem is that privacy consent is fictional. The law relies a lot on consent. The GDPR, in fact, one of the lawful bases is consent, and it's relied upon a lot. If you get consent, that's it. You could use the data. And people regularly consent, but I think it's fictional. Consent is meaningless if people really don't understand what they're consenting to. And this includes, now the US gets critiqued a lot for opt-out consent. The idea that if you don't do anything, that you consent to whatever a company wants to do with your data, if you don't opt out. And we know that's all BS, right? That's not consent. So GDPR says, we're better. We have affirmative consent. Affirmative consent is just clicking an accept button. It's the stupid cookie banners again. But that doesn't mean you understand it, right? You click the accept button. You get the terms of use on a site. Here's 51 screens. Accept button on the screen number 1. Well, you could, in fact, put the accept at screen 51 and make people click next. Or you could say, look, it takes the average reader 30 minutes to read our terms of service and our privacy notice. So we will gray out the accept button for 30 minutes. And then you can keep going. No, we just let people click accept because we know it's a fiction. It's all a fiction. It's bull crap. But we accept it. And the law says, yeah, we're going to let, then you've consented. Now you've clicked an accept button, so it's all okay. But it's not okay. People surrender their power all the time. Now here they'll consent, and they give up all sorts of protections and things they could do. Now, sure, the GDPR gives some protections, but it gives a lot of power once you give consent. And the problem is that the benefits are very clear. They're immediate. And privacy concerns are risks that are abstract in the future. You're not thinking about them. Just go back to the anecdote with just the other night with my son. The benefits are cool. I get to play this cool little game and see how my face looks, and he wants the immediate benefit there. I have to, there's facial recognition. What if, like, this were sold to like Clearview AI, and then your face was used and recognized, and Trump's government agents jumped out at you and hauled you off to the who knows where and threw you into a prison in El Salvador. Now that's at least more concrete, but a lot of times it's like, okay, well, what's the risk there? I don't know, what companies might have it, what will they do with it, how could they possibly use this facial recognition against me? And I can explain, yeah, there's a chance that this could be used in some terrible ways, and is that likely? What could happen? I don't really know. And so they'll, it's hard. You just most consumers are like, look, I just want the benefits, there's risks, I can't figure it out, I'll just give up. AI makes this even harder. With AI, it's even more complicated. Understanding the risks of AI are almost impossible. I'd say very challenging in the slide, but it's practically impossible because I don't know what these algorithms are really going to do. I'm not an expert engineer trying to figuring this out. And even if I did, I don't know the data that they're trained on. They depend on the data that they're trained on. And I don't know all that data. I can't compute in my mind billions of data that are fed into this thing. So I would actually need my own team of expert computer scientists, the data set, which is constantly evolving and changing, and they would have to then run tests and experiments on the AI and then tell me the results to help me make my decision about risk. I can't do that. It's not feasible. It's impossible. And then the scale. I'm talking about one company. Now I have to do this for hundreds, thousands of companies? How am I going to do this? It just doesn't compute. It doesn't work. The only way for there to be meaningful privacy protection is it has to be structural in nature. It's got to go beyond putting the onus on the individual and focus more broadly on providing protection. And I think that the key is that instead of trying to give people control over their data, which isn't bad to the extent that we can, the law should try to bring the collection and use of data under control. There's a difference. Yes, data is out of control, but it doesn't mean that we throw it onto the individual to somehow control it. The law needs to have our back as consumers. And I think the law can do this with a duty to avoid unreasonable risk. Organizations should have a duty to avoid unreasonable risk. And this duty should exist even when consumers consent. Even when I consent to something, the law should say, we're going to protect you against unreasonable risk. Yes, sometimes things can be bad. That's fine. As long as it's a reasonable risk, I think consumers should be able to take that. But unreasonable risk, that's out of bounds. There shouldn't be a gotcha. Well, it was buried in our privacy notice and you consented. Should not be an excuse for that. There are other duties I discuss, but I don't have time to get into all of them. But the gist of it is this, that we go to the supermarket to buy milk. We don't have to worry, like, will this milk kill us? Although now in the United States, we do, since our head of HHS wants unpasteurized milk now, and who knows what else he really is trying to kill us. But ordinarily, you go to the supermarket, look, you can focus on how well does the milk taste, what's my favorite brand, is this milk cheaper than another milk? But you don't have to become an expert in milk production or pasteurization. You can buy milk and you know that someone who has better expertise than I do about milk has my back. I don't have to become an expert in milk. And I think the same should apply to technology. Because it used to be in the past that milk would poison us. In the United States and in the UK, formaldehyde was put into milk. It was put into milk because it sweetened it up, so when it went sour, it could make the milk pass as non-rancid milk. And babies would start dying. And people thought, oh, why are these babies dying? Well, because you're putting poison in the milk. Eventually, we had laws that said, hey, we don't do that kind of thing. We're going to make sure on the front end and on the back end that there's protection. On the front end, we're going to have safety standards. We have that for cars. We have it for drugs. We have it for food. You can't just go out and do whatever you want. There's a minimum safety standard. So there's still a range. There are safer cars and less safe cars. There are different things, but still you can't buy a car that's going to blow up on you, or food that's just going to just kill you outright. But there's also liability after the fact. If the car does blow up on you, you sue, and there's a lawsuit. And this gets to my biggest point, which is accountability. That if we really want to protect privacy in today's age of new technologies, we need to mandate accountability. We need to hold companies accountable. And the myths that we have, and a lot of the law often doesn't do this. The rights don't really do this. They throw it onto the individual, but they're not fully holding the companies accountable for the harms they're creating. And I think that the law needs to do a much better job about this. There's a great quote that I like from Charlie Munger. And he says, show me the incentive and I'll show you the outcome. Companies are actually really good at following incentives. They do this really, really well. You give them an incentive, they will do it. They are machines designed to achieve incentives. We go astray when we look for them to act morally or whatever, but we don't go astray when we say, look, put out the right incentives, they will follow those incentives. The problem with the law is it doesn't do that. It often just hopes that companies are just going to be good and they're going to be nice and they're going to do whatever, they're going to somehow act ethically when they're not designed to do that. They're designed to make a profit. That's what they're built for. They are sharks. We shouldn't expect a shark to suddenly become a vegetarian. It's just not the way they work. So we hold them accountable. And they should be accountable before they put out the products, and they should be accountable after they put out their products. And if we hold them accountable significantly, so if they put out something that harms people, they should pay, and they should pay really hard. It should hurt. And a company to say, wow, that creates a world of a lot of uncertainty. That puts us at great risk. Because if we use data and we don't fully know what could harm people or not, and some regulator could come down the road and say, oh, that's harmful, or a court could say in a lawsuit, oh, that harmed people, and we didn't know that, that could put us at risk. We might not be able to sleep well at night. A CEO of a company might not get a good night's sleep. And I say, good. Because that's the situation we're in. We are facing these risks. We are facing these uncertain harms. We can't sleep well at night because of what's going on. Why should they? But we constantly hear about their woes. Oh my gosh, the sleep of Elon Musk, the sleep of Mark Zuckerberg. Oh my gosh, how risky it would be if some regulator were to say no to them. I'm sorry, but good. You should be at risk. Using data should be risky. It should be treacherous because it's treacherous to us. And if it is risky for them, maybe they'll be more careful. Guess what? That's actually what makes them more careful. Maybe they should say, oh, wow, this risk could potentially harm people. We're not totally sure. Maybe you shouldn't do it, which is my next cartoon. Here's a tech CEO. There's a 50% chance that the technology we're developing will destroy the world, but there's a 100% chance that it'll be profitable. So it's an easy policy equation. Let's do it. This is the world that we're living in, but this need not be the world that we live in. We can have meaningful protection, better protection, but the law needs to get a lot tougher and a lot more realistic to do so. Ultimately, protecting privacy is really an endless task. Privacy is always going to be at risk because technology changes all the time. What people do, human activities change all the time. We're in a world of constant change, and there will be constant threats to privacy. But we shouldn't give up. Yes, it's endless. But if we figure out the lessons that we've learned with other things, like cars and food and drugs, lessons that I think, unfortunately, we're starting to forget, at least in the United States, I think we can really make some headway with privacy. But we have to really adhere to these fundamental ideas of incentive, accountability, and not putting the onus on individuals. Thank you, and I'm happy to take some questions. I think we have about 20 minutes, so yeah, go ahead.
Thank you very much. That's great. And my name is Emma. I'm a PhD researcher. Oh, thank you so much. I will wait for that. Hello. Okay, great. So my name is Emma. I'm a PhD researcher at the University of Oxford, but also an American, and so very much looking back and forth to seeing how the US and EU are going about this. I can't say I disagree with you on anything. I will say I'm obviously familiar with your work. You mentioned, I have a few questions. I'll keep it very brief. You mentioned consent as something that's not very functional, but it seems that you still want to keep it. And I think you say this in an article that you've written as well. I would really appreciate if you could expand on that. And for me, from this talk, actually, in terms of accountability, absolutely. But accountability to whom in the United States specifically? Because I don't know that we have the infrastructure as it stands to have really an agency be the people that industry reports to, or what agency would that be? As you've said, as the situation is now after Loper Bright, after all of Trump 2, or whatever you want to call it, it's looking quite dire. So Thank you so much.
Yeah, I'll start with the second one first. It's hard at this point. The U.S. is, I think, unfortunately, I hate to say it, in a death spiral. I'm losing hope every day. Every day the news comes out and it gets worse and worse. On the shadow docket, the Supreme Court now is kind of very strongly indicating that independent agencies, of which the FTC is one, are probably going to be no more. The 2 Democratic commissioners have been fired by Trump illegally. I don't think the FTC is really going to be a credible enforcement body anymore, and it was pretty good, and that would have been the candidate for a body that companies could be accountable to, as well as we still have the civil liability system that is something in the U.S. that has actually worked pretty well. It does have costs, and it has its problems, but it actually works pretty well. I think even better, especially with class actions, than a lot of the systems here in the EU. When laws have a private right of action, which I strongly support, they get enforced pretty vigorously. So there's a law in Illinois, the Biometric Information Privacy Act. It's actually, companies don't mess around with that law because there's a private right of action, and the courts really enforce it. Now, of course, anything that's good is going to be destroyed in the United States, unfortunately. So it's just a matter of time before that goes away. And I don't know how to deal with the larger structural problems in the U.S. because I think that ultimately a lot of what I do and write kind of depends upon the rule of law, depends upon government acting in good faith and caring about its people and trying to do the right thing. When we're out of a society like that, when we really are just a bunch of malevolent, kind of a dictator and malevolent groups in the government, it's hard to talk about law. It's really just about power at that point. And that's kind of where the U.S. is at this point, that there really is not much rule of law anymore. So it's very sad. But I, as a law professor, I don't really know what to say. It's almost like at this point I have to put on my political science hat and just say, it's about power. Whatever you can do, just do it. But we really can't talk about rule of law because there isn't rule of law. So I keep going as if we had an FTC and talk about the law. If we had law, this is what the law should do. If we don't have law, there's not much to say. On consent, I did write a paper, and I talk about it briefly in the book, a paper called Murky Consent, because I've long struggled with the consent. For years and years, I couldn't figure out, what do we do with it? Because I didn't want to get rid of it. I felt consent really doesn't work very well. It's a fiction, no matter whether you have opt-in consent or opt-out consent, whether you have the, kind of the US-style notice and choice or the EU-style affirmative consent. But if we got rid of consent, then the government would tell us what we could consent to. And I'm not sure that's great either. I might say, look, I want my iPhone. I want my smart doorbell. I want my doorbell camera. I want to use that app that makes me look like a cat and whatever. I want to use some of these technologies. And people might want, should the government say, no, you can't do that? And I think that's troubling too. So the idea of the article was to say that most privacy consent is murky. It's not that we have this consent, the way consent typically works is it's kind of this binary. You get consent and it confers legitimacy and power, or you don't get consent. And I think most consent is in the murky middle. And it should give some power and a smidge of legitimacy, but not much. That's why I call it murky consent. It really doesn't legitimize everything. It doesn't get you all the way. So why don't we weaken the power of consent? And then why don't we, instead of trying, and most of the approaches to consent, really try hard to make consent non-fictional? How do we fix consent so that consent is actually real? And my point is we should give up on that. In fact, we should lean the other way. What if we leaned into the consent being a fiction? What if we said, in fact, the law should say, yes, consent is fictional, we'll call it murky, we'll weaken its power, and then what we'll do is we'll make sure that if we're dealing in a fictional story, why don't we then make sure that the story ends happily for people, that it's fair for people? And so we could say, look, that's why we impose duties. One duty is a duty to avoid unreasonable risk. I talk about other duties. I mention a duty that Neil Richards and Woody Hartzog have written a lot about, a duty of loyalty, which is to look out for the interests of the consumer, the person, put the person's interest ahead of the company's interests. which I think is another important duty. There's other duties as well, duty to avoid thwarting expectations. So there shouldn't be a gotcha, oh, wow, we tricked you, which often happens with data today. So a lot of the system is premised on the fact that we give our information and we decide, the consumer decides what information I'm going to give. So okay, I'm going to tell them I like water and I like this product and I like to drink Diet Coke rather than Diet Pepsi, and that's pretty innocuous, so I'll give them the information. But in today's world of AI, that everything, even innocuous data, can be used to make inferences about all sorts of other things about people, including sensitive things like health. So a famous privacy anecdote from more than a decade ago involved a store called Target that looked at people's purchases at Target to determine if they were pregnant. And the purchases that would give away pregnancy had nothing to do with pregnancy. They seemed like people wouldn't be, it's actually, did you buy cotton balls and unscented products? And that was, and other things that then triggered the algorithm to make predictions about pregnancy. And this is the problem. People are, wow, that's a gotcha, right? You didn't think, I'm okay with them knowing I bought cotton balls, but I'm not okay with knowing pregnancy or health or other things. And these days, it's almost impossible to buy things or do things without inferences being created. It seems that now everything has politics these days, right? I can't buy a pillow now without politics. There's the My Pillow guy who's a big Trumpist. So you buy, My Pillow, it now gives away your politics, and so on and so forth. So I think that ultimately we really can't, the law should just make sure we're not going to be in these gotcha situations. And if I give this information, companies shouldn't be able then to turn around and then infer other information about me that I didn't want to give to those companies. And there are other duties as well, but the gist of this is that the law needs to have our back. The law needs to make sure the story ends happily ever after for consumers, which the law can do. And then it's okay to consent. Then it's okay, I consent, and then the law makes sure that I'm not caught in this gotcha situation where it's going to turn out really badly for me. And then that's fine. Then we say, okay, the stakes are lower, the power of companies to use the data that's consented to is lowered, and then consent can work. But otherwise, I think this current situation where consent is this all or nothing binary, that company get the data and then can do whatever they want, that is untenable, and I think that's what makes consent really pernicious and does more harm than good. Yeah. Yeah, I mean, I think ordinarily I would say the government would be, I put a lot of weight on the government. We kind of depend on, a modern, effective, civilized society needs a effective government. And fortunately, the U.S. that's gone. So yeah, we have civil society. I think that they can help, but there's only so much that can be done, which is why it makes me incredibly sad whenever I talk about the U.S. because it's hard to find sources of hope and any source of strength. Trump's going after civil society. It's starting to go after a number of organizations. I mean, one that was actually interestingly one of the more moderate civil society groups, the Future Privacy Forum, was doing something on AI that was really not controversial at all. And a senator, threatened this organization and its funders, which were companies that wanted to do something more pro-privacy, all got spooked and caused the organization to kind of pull back. So when you have a malevolent government, civil society struggles as well. Yeah.
Well, before anything, thank you so much for your lecture. I'm Felipe Medon. I'm professor at FGV Rio Law Brazil. I'd like to refer to one of your last papers on scraping. And the difference between how we can tackle scraping in the age of AI. In your paper, you claim that even though scraping violates tons of legislation around the world, we should see it as inevitable because it's something that's already there. We realize it's inevitable. So we needed to focus on the public interest as a parameter. That's, if understood well, you claim. So my question is, in practical terms, how can we rely on this public interest to achieve this goal if, as you've been discussing, institutions and regulators who have the power to hold companies accountable can't or may not do it for several different reasons?
Yeah, a couple of things. I'll just make a slight edit to what you'd said. I wouldn't say that the reasons why we embrace scraping is because it's inevitable as much as because there's actually some good aspects to scraping, that a world without scraping could be a lot worse. And the reason why we think that scraping should be allowed in certain circumstances is that you have researchers, journalists, and others that need to get information that might not be able to get the information they need. And you also have, if you really stopped all scraping, the companies that have a lot of data would get more powerful. It would give more power to the biggest companies like Meta and X and others that would, I think, be very problematic. Scraping does, equalize certain things to some extent, and that was a concern of ours. So we wanted to say, okay, we would allow scraping as this kind of exception to privacy laws to the extent there are a lot of aspects of scraping that could still be further restricted. Even with privacy laws, we want to bring as much in there, but there's still certain things that just, it's incompatible with scraping. This is a paper I wrote with Professor Woodrow Hartzog. There's some certain things that are just incompatible. But for those, maybe we make an exception if scraping is in the public interest. And that does then depend on, well, who defines public interest? It's a tough concept to define, but there's a lot of tough concepts to define, like free speech and freedom and other things. But, we can do it if we do it, again, in good faith with smart policymakers doing that. Of course, so much depends on, a government that is good. And this is the problem. What do you do in a society if you can't rely on the government being good? And it's hard because I don't know, because then it just becomes power. That's why we have government. Otherwise, it's just the law of the bandit. It's a breakdown of society. You either have a kind of authoritarian, totalitarian style government, or you have the law of violence. The toughest, anarchy, where you basically have like gangs running. It's kind of what's going on in Haiti right now, where gangs are just kind of controlling things. Those are our choices. But I think we've learned through history, like a good government that cares about people, that's a democratic government, works well. So it's hard. I don't have answers to like what do we do in the absence of that. It's hard to know what you do. Yeah, in the back, Neil.
Thanks for characteristically uplifting and cheerful talk. So I was going to ask you about loyalty, but self-serving, but then you answered that already in response to Emma's question. While you were talking, I couldn't help but notice you were standing next to signs for Google and TikTok, and some of the companies you're criticizing. What do you think is the relationship between privacy and manipulation, and privacy law and manipulation? So thinking about things like infinite scroll, or TikTok's alleged use of data to wait till people start to flag and then hit them with something they know they're really going to like to sort of restart their mechanisms. Is privacy, I think you're going to say privacy has some relevance, but is privacy the best way to get at that problem, or is something else what we need?
Well, I understand privacy in a slightly different way than others might understand it. I kind of see it as a family resemblance concept. So I see privacy as not just one thing, but many different related things. And so I'm less concerned about, I'm generally would err on the side of like, let's throw it onto the big tent of privacy. And I think it's worth having the conversation about manipulation with the conversations about privacy, to the extent that there are certain tools in privacy that can help address the manipulation problem. That doesn't mean that manipulation is the same as other privacy issues. It doesn't mean that we use the exact same tools, but we can learn by seeing, okay, where are the privacy, where personal data is involved. Sometimes things involve, how individuals will share their data, which is then used to manipulate them. So certainly we can use some tools from privacy law there. But there might be other things where just the infinite scroll. Well, that might not involve personal data. That might just involve a design, a kind of what's called a dark pattern, which is a design that manipulates people to try to not do certain things that a company doesn't want them to do. And it's related to privacy, and it is kind of about trying to control people. It's trying to shape their behavior, although it might not necessarily involve personal data. But I would consider it, in the same conversations. I think it's worth discussing together. But that doesn't mean the answer to the scroll is going to be, oh, let's do the exact same thing for the collection and use of personal data. However, what's interesting is that we do see in the laws in the US, and some of the state laws are starting to address dark patterns. And they're in privacy laws. And I wouldn't say let's stop that and make like a whole separate law. It's not clear a separate law would even pass. But they're in the privacy laws, which is a good thing, right? The laws are starting to do it. It happens in privacy. Great. So I think, the answer may not sound totally satisfying. So, well, consider it with privacy when it's helpful to consider it with privacy. When there's a difference, acknowledge the difference and say, well, maybe privacy tools can't get you all the way there. We need something else, so then use something else. But I would say just don't get hung up on the fact of like, okay, is this privacy or is this not privacy? Let's figure out the boundaries and spend the next months figuring out conceptually where privacy begins and ends. And I'm having a kind of an academic debate with a group of other professors about this very question. And I kind of think we need to move past this question about what is privacy and more about what should we do about particular problems. Because we can actually do particular problems if we're caught in this kind of endless debate about what privacy is, that we forget about the problems we're actually trying to address. And one other thing about the manipulative designs that I think is really interesting is that this is like the Neil and Woody show today, but Woody Hartzog, my co-author on the oh, there you are. Okay. So he wrote a wonderful book. I'll actually talk about this book in the next hour on design. And the law and policymakers have been very shy about regulating design. Oh my gosh, we can't regulate design for privacy because that would, in fact, be second-guessing technologists. And who are we as policymakers to tell technologists how they should design their products? And so the law has been very reluctant to do so. Woody's book is wonderful in that he really shows concretely how design affects privacy and why it's really impossible to protect privacy without regulating design. So we're at this impasse. But what's interesting is that the term dark patterns, which was coined around 2010 or so, I'm not sure the date, by someone named Harry Brignall, he called it a dark pattern. Now, all of a sudden, policymakers seem to be okay with regulating dark patterns. So it's interesting, just a change in terminology. Like, let's call it a dark pattern. Really what it is design. It's manipulative design. It's the same design that they've shied away from, but now that it's a dark pattern, they will actually go and regulate it. So it is possible to regulate design. They can regulate design. It's a sort of strategy about how we define it. I think this is a very interesting story about we can and should regulate design. It affects privacy. It affects other things. And the term dark pattern has actually been a great boon for regulation of design. Yes. Oh, sorry.
Thanks for your lecture, Professor Solove. It's nice. I'm a big fan of your cartoons. They are very helpful. My question to you is very much, well, I'm an adjunct professor on cyber law in Germany. My question to you is pretty much in the marketing strategies. I mean, the minute you go to the US, it's a completely different situation in Europe. You get like inundated with a lot of campaigns, whether it's a spam, unsolicited calls. But the same is happening now in the terms of generative AI, deep neural networks. My question to you is, what do you think? Do you think these like companies are relying on, generative AIs, deep neural networks to actually provide you a service? Like, think about music, Spotify, Apple. Are they obtaining our consent just very much based on the clicking on the terms and conditions? And would that be sufficiently be proved under the laws on whether if we are located in Europe or in your case in the US? Is this sufficiently proved to be something that we agree upon, to receive all these different, marketing? This is not new. I mean, where there was this discussion on online targeting advertisement, back in the day with the FTC. I mean, this is not new. Now it's just completely now in the generative AI. I would like to hear your views on this.
Yeah, I think that the current system of consent is broken. So currently, I don't think the consent is adequate. We are getting inundated by everyone's AI. It seems that it's hard to escape it now. Everywhere you go, it's like, do you want to use our AI tool? Microsoft, do you want to use our AI tool? And I say, yes, I will use your AI tool when you figure out the difference between my microphone and my speaker. There's so many obvious things that, like, how about AI to actually, reorganize your ridiculous menus to find everything in your software? Or how about fixing a 20-year-old bug, Microsoft, and then I'll use your AI. Or, Google, how about coming up with something better than Teams? If you can't do Teams, I don't know how good your AI is going to be, and so on and so forth. So we're constantly getting now the AI kind of thrust upon us, almost. And it's also, that's the AI that we're being told about. There's a lot of AI that's kind of going on behind the scenes. AI is not one thing. It's many different types of AI, many different things. And a lot of it it's not, some of it's new in that the computing power is greater, the algorithms have advanced, but it's still an old technology. These technologies that form the backbone of AI are older technologies that just now, because of the data and computing power, are becoming more useful. But we've had these things going on for a very long time. The Target anecdote I told you about was more than 10 years ago. Today, you could use it as a modern AI thing, and everything's kind of been rebranded AI. But it's been with us for a long time. Yes, I think we don't really deal with it adequately. So we're already being subjected to AI, whether we like it or not, a lot of it without our consent. And then there's the AI that's being thrust upon us at every turn, where we're being asked to consent or use new AI tools, which are going to keep coming and more proliferating, and it's going to be harder to refuse them. So the latest is an annoyance where I go into PowerPoint, and every time I go into PowerPoint, it's like the AI now suggests how I should design my slide. And they're all like these crappy ideas. And I don't like it. And it says, I can click out of it, and it says, the only option is click out of it until I restart PowerPoint. I can't just say, go the hell away and never come back until I tell you. It's now every time I restart it, there it is again. And we see these techniques. The companies are trying to force our consent in certain ways, or just make it so annoying for us not to consent. And I think it's going to get worse, because they're all going to want to thrust their AI upon us as they battle for AI supremacy. I think that's a tricky thing to say. There could be like a standard interface or force a interoperability of interface. That might be very hard. I think there's already struggles with just data portability to begin with, let alone interface. But certainly interface has just a dramatic effect on behavior. And interfaces really operate with a lot of different metaphors for how to visualize things and think about things. And we still have interface vestiges from long ago. You know, the floppy disk, which like a whole generation has no idea what the hell that is, being used for save. Or a trash can being used for delete, when delete has nothing to do with trash. It's actually just stored in a different place, or just designated with a different thing, but it's not actually deleted. But we have all these misleading interfaces and manipulative interfaces. So I definitely think we need to regulate interfaces. I'm just not sure, you know, can we create interoperable interfaces? I'm not sure we could do that, but certainly we could do certain things to address, you know, manipulative or deceptive interfaces. I think we're out of time. I actually am going to do a talk on privacy books after this. So if you haven't had your fill of me, I'm going to talk now about a whole bunch of privacy books. I'm going to go through about maybe more than 50 books over the last like 60 to 70 years. So if you're interested, stay on. Otherwise, I certainly understand if you've heard enough of me.